In terms of policy issues to consider, from a criminal law point of view, Parliament would be considering an exemption for conduct that is otherwise criminal, namely the crimes of aiding suicide and murder, which correspond to the two different types of physician-assisted dying. An exemption is needed to shield physicians and possibly other medical practitioners, such as pharmacists and nurses, who may provide assistance in physician-assisted dying from criminal liability. As a preliminary matter, there sometimes appears to be some uncertainty, at least among some Canadians, about what physician-assisted dying is and what it is not. Physician-assisted dying is not the act of withdrawing medical treatment that a patient does not want, nor does it refer to a patient's right to refuse treatment or medicine in the first place. In these circumstances, if death does result from the withdrawal or the refusal of the medication, this is not a crime because the cause of death is the underlying medical condition. No mentally competent person can be compelled to receive treatment they do not want, as this would amount to an assault in criminal law and also a civil wrong. So, physician-assisted dying refers to conduct that involves someone, a physician, actively participating in bringing about the death of another person. Before Carter, this kind of conduct in any form was criminally prohibited in a variety of ways. The court considered that only two criminal code provisions were at the core of the prohibition against physician-assisted dying. First, Section 14 of the Criminal Code, which states, "No person is entitled to consent to have death inflicted on him, and such consent does not affect the criminal responsibility of any person by whom death may be inflicted on the person by whom consent is given." Section 14 therefore operates in conjunction with the crime of murder, which is in essence the intentional causing of another person's death. Section 14 means that a person's consent to die has no effect on the criminal responsibility of one who caused their death. It has always been murder, even if the victim wanted to die. Second, paragraph 241B of the Criminal Code, which reads, "Everyone who aids or abets a person to commit suicide, whether suicide ensues or not, is guilty of an indictable offense, punishable up to 14 years in prison." These two provisions prevented a person from receiving a physician's help to die in all circumstances. So it is critical to note, like most other criminal provisions, they are of general nature, and they also serve to prevent non-physicians from helping others to die in situations that are totally outside the context of physician-assisted dying. These two provisions were at issue because there are two ways in which a physician can help a person. One is by providing the person with the means to end their own life, such as by providing or prescribing a lethal dose of drugs. The individual who receives the assistance takes the necessary final actions that cause their own death. They are the agent of their own death with someone else's assistance. This is known as physician-assisted suicide. The other way is generally referred to as euthanasia, and it is where the physician directly causes the person's death, typically by injecting a lethal medication. This does meet the definition of murder, which is the most serious offense in Canadian criminal law, and is punishable by a mandatory sentence of life in prison and at least 10 years of parole ineligibility. Murder is considered the most serious offense under Canadian criminal law and in most other countries because one person is actually causing the death of another, rather than just helping that person end their own life. The differences between the two practices, including the different types of risk that each could entail, formed no part of the litigation before the Supreme Court. The court did not differentiate between the practices, but dealt with both under the general term physician-assisted dying or physician-assisted death. I may have misspoke when I generalized slightly when I indicated that it was a term that's well understood. Well defined. It is well defined, but there are subcategories of euthanasia. So, in the context of the Carter case, the court was only ever speaking of what could be called voluntary euthanasia, which is exactly where the person is competent to make the decision. So they are aware of their circumstances, they have received the necessary medical information, they are capable of understanding the consequences of the different decisions that they might make. And such a person who requests assistance to die, if they received that assistance from a physician, that would be called voluntary euthanasia. It could be involuntary if for instance, a physician terminated the life of a patient contrary to their wishes. That could be called involuntary euthanasia. There is another subcategory that could be called non-voluntary euthanasia, which would be where the wishes of the patient are unknown. So I thought it might have been best to try to avoid some of these complications, but it turns out it's impossible.
You said that there are differences in terminology used in discussions by different groups, and there are subtleties implied in their usage. So we know that in Quebec, the term medical aid in dying is used. I have heard that palliative care prefers the term physician-hastened death. And we ourselves see in the Carter decision physician-assisted death, physician-assisted dying. We hear euthanasia, suicide. So there are a lot of terms used. My question to you is, from a legal point of view, what is important when we think about the terminology that will be used in the legislation?
Well, from a criminal law point of view, what would be important to be clear on is which are the criminal offenses for which we're going to create an exemption. So there is an offense, it's called aiding suicide. That doesn't necessarily mean that it wouldn't be possible or appropriate to coin a different term for what I'm calling physician-assisted dying today. But the legal elements from a true criminal law perspective should be clear so that physicians and other medical practitioners can know what they're able to do, what they're not able to do. That's what they will want to give them the confidence if they're otherwise willing to provide this service. So the legal clarity from a proper criminal liability point of view is very important. In terms of, at a more sort of social policy level, what do we want to call this practice? That is a very challenging question. I mean, there's even finer distinctions to be made. And so, for instance, I could bring to the committee's attention that some of the stakeholders who spoke to the federal panel, and you will all see this when you peruse the report, they were also drawing a distinction between dying and death. So dying is a process, whereas death is an event. And so some have even made the recommendation that we should never be calling this physician-assisted dying. Many palliative care physicians feel that that is what they already do. They assist patients who are dying by making them as comfortable as possible through the dying process. But there is also a danger with these kinds of terms, and that is that people don't necessarily understand what they mean. So there was some polling that was done at the time when Quebec's legislation was before the National Assembly, when Quebecers were asked what they thought aide médicale à mourir, or physician-assisted dying, meant. And I think something close to 50% said that they thought it referred to withdrawal or refusal of treatment, which has been legal in Canada for 20 years. So if people are mistaking what a general phrase means, that's not going to facilitate discussions between doctors and patients, and it could confuse things. So I fully recognize the difficult nature of choosing the right terminology on this. One overarching consideration the committee will encounter very quickly is the divided jurisdictional nature of physician-assisted dying in Canada. Under our Constitution, Parliament has exclusive jurisdiction for the criminal law. The Supreme Court confirmed in Carter, at paragraph 51, that Parliament has the power to make laws that touch on health on grounds of dangerousness or social undesirability. The criminal law is about morality and fundamental values, such as in relation to concerns about the devaluation of human life. It can also be about public health, such as concerns over risk of abuse and about the safety of individuals, and in particular, vulnerable individuals. Parliament's concerns from a criminal law perspective in the context of PAD relate therefore to the minimization of risks and the protection of social values that are considered of fundamental importance in Canadian society. Aspects of physician-assisted dying regulation that could be seen to fall squarely within Parliament's criminal jurisdiction, such as the essential elements of an exemption to otherwise criminal conduct. There are also elements that could be seen to fall squarely into provincial jurisdiction, such as conscience protections for physicians that seek to balance the competing rights of physicians against those of patients. There are also issues that could potentially be regulated by both levels of government, but again from different perspectives. By Parliament, from the perspective of minimizing risk and protecting public health and morality, and by the provinces and territories from the perspective of making available a beneficial health practice.
So there isn't, in your best expert opinion, there aren't particular aspects of assisted dying that Parliament itself at a federal level should address in legislation, and those that must be left to the provinces?
Well, surely any amendment to the criminal code that says these are the conditions under which conduct that otherwise meets the definition of a crime shall be free from criminal liability. That is exclusively the responsibility of Parliament. There are a variety of ways that Parliament can go about that. It can put very little in such an exemption. It could say, for instance, that so long as the conduct is in accordance with a very detailed provincial law, then that will result in an exemption for criminal purposes for the same conduct. Or Parliament could say, for the criminal exemption to apply, we're going to determine to which offences it applies. We're going to determine under what circumstances it applies. So it would really be with respect to the fundamental circumstances in which physician-assisted dying is available that there's a very strong claim that that is Parliament's jurisdiction as a matter of
the
criminal
Supreme
law.
Court decision speaks to charter rights, not only of patients but also of physicians. And patients, therefore, they have the right to access, but physicians have the right to conscientious objection. So I'm wondering if you have any advice to offer us on how to reconcile what are potentially competing charter rights.
Yeah, I think that that's going to be one that's, as my colleague was mentioning, the issues around and the approach that's taken to how and when physicians may object, that's going to be really a part of the provincial territorial response, most likely. So that, to my mind, would be one of sort of the lower order issues that arises for this committee in terms of what the federal response is going to be. But at a very general level, as with other cases where the court has had to deal with the issue of competing rights of different parties, it always comes down at a very general level to a kind of balancing, and whether whatever balance has been struck is reasonable and proportionate in the circumstances. And I would think that overarching would be the decision and the holding in Carter that there has to be access. So that's sort of the baseline, is whatever approach would be taken to give appropriate respect and protection to the freedom of conscience rights of physicians would have to be reasonably balanced by access for the rights holders that were described in Carter.
Okay, so you're suggesting that it's the provinces that would deal with this particular aspect, the competing charter rights.
Yeah, currently the provinces and territories do have legislation and policies in relation to the rights of physicians to refuse to partake in certain types of medical practices. So it is definitely something that the provinces and territories already are responsible for. There's a fairly limited scope of action on this particular issue from the Parliament's criminal law jurisdiction.